Hello friends, in the series on the income tax cases, today we will discuss the case of Deputy Commissioner of Income Tax versus Kashmir Steel Rolling Mills. This case has been reported in 104 ITR Tribunal at page number 684. The matter has been decided by AMRITSAR ITAT and this case has been decided on 16th January 2015. At the face, it seems a little bit impractical that the case of 2015 is being reported in the latest ITR tribunal, but it can happen. If the ITR feels that some case was very important and which was left unreported in the ITR, it can report it. This case is on the section 154. The section 154 gives the power to the assessing officer to rectify the mistake apparent from record, whether this mistake is on behalf of the assessee or whether this mistake is on behalf of the department. The main purpose of section 154 is that no mistake apparent from record should continue, and if the department suo motu or the assessee makes an application under section 154, then that mistake can be rectified if that mistake is mistake apparent from record. So the moot question for rectification under section 154 is that what are the mistakes which are apparent from record. Calculation mistakes are the best example of mistake apparent from record, but in this case a little bit ticklish point was before the tribunal. The assessee filed its income tax return for the assessment year 2007-8. When the return was being filed, the assessee received excise duty refund and interest subsidy during the year, which the assessee treated as revenue receipt and paid the tax on that. After some time in 2011, in a High Court judgment of Jammu and Kashmir, the Honorable Court held that excise duty refund and interest subsidy is a capital receipt and not a revenue receipt. The name of the case is Shri Balaji Alois versus Commissioner of Income Tax. When the assessee came to know of this decision, the assessee on the basis of this decision filed a rectification under section 154 before the Assistant Commissioner by saying that please rectify my mistake. I have included that part into my income, and according to the judgment of the Jammu and Kashmir High Court which has been decided in 2011, the name of the case is Shri Balaji Alois versus CIT. It has been held that excise duty refund and interest subsidy is a capital receipt, so my return should be rectified under section 154. But the Assistant Commissioner was not happy in rectifying the mistake, so the assessee moved to the CIT appeal on the rejection of the application by the Assistant Commissioner under section 154. The CIT appeal allowed the appeal of the assessee by saying that this is a mistake apparent from record and it can be rectified under section 154. The department moved to the ITAT and ITAT also upheld the point of the assessee and the order of the CIT appeal that if High Court has passed the order and due to that order, if the assessee makes an application for the rectification under section 154, if that matter is covered by the decision of that High Court, then that mistake can be classified as mistake apparent from record and that order can be rectified. Friends, although in this case the assessee has got the relief, but this case is a little bit very dangerous in the sense that if some decisions come, then there will be a lot of litigation, like in the case of checkmate decision of the Supreme Court on the Employees Provident Fund. The department will now try to move the rectification under section 154 if the time permits, if that application is within the time limit. So this case can be very promoting in the sense to the litigation that on the basis of the decisions by the various courts, the assessee as well as the department will try to go for section 154 rectification. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus KASHMIR Steel Rolling Mills, and this case has been reported in 104 ITAT Tribunal at page number 684, and the date of the judgment is 16th January 2015.